Well, welcome everyone to the Public Safety and Veterans Subcommittee. And also, I want to throw a shout out to all the Latina mothers out there. Today's the Latina Mother's Day, so May 10th. And Latin America and Mexico is Mother's Day, so happy Mother's Day. And also to my colleagues.
Thank you.
With that, I'd like to call this meeting to order. Call to the public. We have one card. Candace, come on up.
Good morning. Good morning, Councilman Nowakowski, Vice Mayor Pastor, Councilwomen Gallegos and Williams. My name is Candace Freemow, and I've resided with my husband at 13626 North 18th Avenue since 1977. We've been active in our neighborhood and community for many years. Among other commitments and responsibilities, I am privileged to serve as the District 3 appointee on the 301 Neighborhood Block Watch Grant Program Oversight Committee since 2013. I have been elected all 4 years as the vice chairperson and serve as the bylaws subcommittee chair. The bylaws were written by City Legal and formally approved in December of 2014. This governing document does have specific provisions for the amendments. Our committee has historically had a chronic problem with appointments and vacancies. The 301 Neighborhood Grant Oversight Committee has attempted to bring to Public Safety Veterans Subcommittee 2 bylaw amendment recommendations. These have been blocked by both the mayor's office and the police department. There have been several different instances that we have been told these recommendations would not be moving forward. As per the ordinance amendment May 2nd of 1995, and I'm paraphrasing, the Oversight Committee is only beholden to this committee and the City Council. We have never in recent history had to go to the mayor or have the police department approve any of the recommendations that were being made. Last week, May 4th, the chairperson and I were called out on the sidewalk a few minutes prior to the beginning of our regular oversight meeting and were told by both Quellen and Corey that neither the mayor or police department were supporting the recommendations and would not be going to the Public Safety Veterans Subcommittee. When I asked for a written statement, their response was it will come from the police department. At the appropriate time in our agenda, I asked fiscal management staff to provide an update on the agenda at our next meeting. The following morning, an email sent to the chair and vice chair from Ms. Salea stated that staff will not be doing so based on the conversation that took place before the meeting with the chair, vice chair Quellen, and Corey. I respectfully request that the subcommittee allow for these bylaw recommendations to be placed on your agenda for discussion and action. If it's the wishes of the committee to not support the recommendations, so be it. But having these recommendations stopped before this committee even has the privilege of debate is against the procedures we have historically been complying with. Our work is being circumvented. Thank you.
Thank you for bringing it to our attention, and we'll see if we can put on the next agenda or so, and we can have a discussion on that. Thank you so much. With that, we're actually, I think we can't really make comments on public comments.
Well, if it's going to go on the next agenda, I also want to know what the process is.
We have an item number 3, Neighborhood Block Watch Oversight Grant Committee. Perhaps we should remove that from the consent agenda.
Okay. Maybe that's where we can discuss all this then. Alrighty, so
As long as we recognize we're going to hold up all those grants. That's approval of the grants.
maybe what we could do is wait until we get to that item, and then we can have a little talk about that. So let's go to agenda item number 1, to approval of the minutes of March 8th.
Move approval.
Second.
All right, there's a motion and a second. All those in favor say aye.
Aye.
All those opposed, it passes. We have consent items 2 through 5, withholding number 3 for conversation.
Move approval.
Second.
Alrighty, all those in favor say aye.
Aye.
All those opposed? We'll go back to, it passes, so we'll go back to item number 3, the approval of Neighborhood Block Grant Oversight Committee's recommendations for 2017 grant program awards.
Mr. Chair, I would be concerned to hold this up because I think this is a separate issue from what was just announced at citizens' comments. This is actually funding 159 grant applications throughout the city that have gone through the thorough vetting and approval. I would like to see what was brought up at public on a separate agenda with whatever information they wish to submit to this subcommittee, because I believe that has always been traditionally the procedure. It always has come through here for approval to change any of their rules, bylaws, whatever.
I'd like to do is hear from Candace really quick if you're in agreement or not.
Did you want me to just speak?
Yes, please.
I would, of course, recommend that the grants be funded as the committee is recommending. The bylaw amendments are a totally separate issue.
Thank you.
Thank you.
Thank you.
And move approval of item 3.
All right, there's a motion and a second. All those in favor say aye.
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 All those opposed? The motion carries. Thank you so much. Thank you, Candace, also. We're on item number 6. We're getting some information on the Arizona Veterans Stand Down. That's for information only. Is there anyone that needs more information on this item?
Thank you to all the city employees and their partners who were involved. Very successful event.
The report was very impressive.
Alrighty, with that, we'll move on to item number 7, the reappointment of our judges and the presiding judge. So at this time, we can do two things. We can actually have the judges come up and we can ask questions, seeing that they've been judges for a while. And I just really want to thank the presiding judge for giving us the reports 2 weeks prior. And we were able to go through it and ask any of those questions to the presiding judge or any of the judges themselves. I'm not sure if we need to go through a whole interview process or if there's a motion out there. I'll
Mr.
welcome
Chair,
that.
I appreciate you sending those reports too. You have appeared before this committee several times on the programs and the new courts that you have instituted and done so very successfully. I have no questions for any of these people that are before us for reappointment. They have excelled. We have never had a complaint, and I actually would be prepared to make a motion if everyone concurs. I move that the Public Safety and Veterans Subcommittee recommend the City Council reappoint Judge Carol Scott Berry to serve a 4-year term as judge of Phoenix Municipal Court ending July 2nd, 2021. Do I need to do these separately? I move that the Public Safety and Veterans Subcommittee recommend that the City Council reappoint Judge Carrie P. Withy to serve a 4-year term as judge of the Phoenix Municipal Court ending July 12th, 2021. I move that the Public Safety and Veterans Subcommittee reappoint Judge B. Don Taylor III to a 4th-year term as judge of the Phoenix Municipal Court ending February 9th, 21. And I further move that the Public Safety and Veterans Subcommittee recommend that the City Council reappoint Judge P. Don Taylor III to serve as the annual term as Chief Presiding Judge of the Phoenix Municipal Court ending June 30, 2018 at a base salary of $165,000.
All right, we have a motion. Is there a second?
Second.
All right, we have a motion and a second. Any comments on
Make a
our
few
recommend?
comments.
Go for it.
I'd like to thank our municipal court system for really being a national leader. It is wonderful when throughout the country, the White House picks our court system to highlight for best practices. And so it was a pleasure to second this motion. I want to thank you for your leadership at the state level as well, and with great innovative programs like the Municipal Compliance Assistance Program. Over 15,000 participants shows the great need and how important the work we do is. I appreciate your partnership on language access issues and other issues of importance to my constituents, and look forward to supporting this motion. Thank you for your hard work on behalf of our city.
Thank you, Mr. Chair. Members of the subcommittee, just briefly, I appreciate those words. It's an honor to be able to lead the court, and I greatly appreciate the trust and the confidence that you've placed in us. I could not be prouder of the court staff and judges for what they have done, and I look forward to continuing to be able to tell you about their successes as we go forward.
Any other comments? All right, with that, I just want to thank you and Judge Carroll, all your community activities and being involved in the community. Thank you so much for being that role model for our young ones and helping out in all the different organizations. Very impressive of what our judges do on their times off. So thank you so much. And our presiding judge, thank you for all those innovative courtrooms that we have. It's just incredible that we have people traveling from across the country just to look at the best practices here in our Phoenix courtroom. So thank you so much. With that, all those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you and congratulations. Alrighty, we're on item number 8, the lobby ordinance.
Mr. Chairman, members of the subcommittee, thank you for the opportunity to be here today to present on some proposed revisions to the lobbying ordinance. With me at the table is the city prosecutor, Vicki Hill, whom I'm sure all of you know, and Jessica Breedlove, who is an assistant city prosecutor. Jessica will do the presentation to outline what the current lobbying ordinance kind of looks like from our perspective as lawyers charged with the responsibility to enforce it as appropriate, and also will then outline some options to consider for the council as a whole and for the subcommittee to recommend with respect to potential changes to the lobbying ordinance. So with your permission, Mr. Chairman, I'll turn it over to Jessica. Thank you.
Good morning, Chairman Nowakowski, council members. As you indicated, I'm going to be talking about the lobbying ordinance. This is a roadmap for our discussion today. We're going to talk about the current law, some of the definitions, enforcement options and sanction options, changes that we already have underway, and then next steps. So currently, the lobbying law is under Chapter 2, Article 30. It has a definition section, registration and reports, exceptions, political contributions, forms and filing, and prohibited lobbying classification. How the ordinance currently works is essentially this. If a paid lobbyist makes contact with an elected city official, from that point, they have 5 days to register with the city clerk's office. This is currently a paper process. And so once they file that paperwork, that triggers disclosure requirements. And those disclosure requirements are quarterly. So if they make any kind of expenditures in regards to their lobbying with a particular elected official, that being taking somebody out to lunch or anything like that, then those items must be disclosed on that quarterly disclosure requirement. Now, if a registered lobbyist indicates that they're not going to make any kind of expenditures whatsoever, there's actually an exemption form. And they can file in a paper exemption form with the city clerk's office, and that exempts them from filing that disclosure, that quarterly disclosure requirements, because they're essentially making an oath that they're not going to be making any kind of expenditures whatsoever. The next section is the exemption section. That exemptions are from registration, and I've put those in your CCR, and you have all of those 8 exemptions. The next one is political contributions. If a registered lobbyist makes a political contribution to a city elected official, then that also has to be disclosed on that quarterly disclosure. And if they solicit, meaning they ask somebody else for a contribution on your behalf, and that results in an actual contribution, then that has to be disclosed on that quarterly report as well. Number 4 is forms and filing. That just indicates that all forms and filings are done under oath. And then number 5 is prohibited lobbying. What that is it's a contingency contract. Essentially, it prohibits a contract with a lobbyist that says, I will pay lobbyist A $5,000 to lobby, and I'll pay them $10,000 if they get my item passed or my item killed. So that's prohibited in the city. And that's actually how the current ordinance works. And as you've noticed, there is no section that says if you don't register or if you don't disclose, this is a violation of law and these are what the penalties are. So we were asked to take a look at it. But one of the important things you need to know before we get to that point is some of the definitions. So lobbying means to communicate with any elected official for the purposes of influencing city action. A lobbyist is a person who is compensated to lobby for a person other than themselves. An elected city official means the mayor, members of city council, whether serving by election or appointment. And then finally, official action means any action or non-action of the city council. So really any kind of communication to influence any kind of action with the city. So in looking at the enforcement mechanisms, we looked all around. We looked federally, we looked statewide, and we also looked at jurisdictions of comparable size. And in doing that, we saw continually some best practices or common practices that started popping up. One of those things is what we call transparency and compliance. And what we mean by that is generally these ordinances are governmental transparency. We want to know if there's a paid lobbyist and if they're having a meeting with a particular elected official. And by compliance is many times it was really wanting an individual to be in compliance over automatic enforcement. And what do I mean by that is cure notices. We kept seeing time and time again, state law, federal law, many of the other jurisdictions had a thing called a cure notice, where if whoever is administering that particular ordinance or lobbyists, if they got information that somebody wasn't registered, that somebody hadn't filed their disclosure requirements, a letter would go out and say, listen, we have information that you should register, we have information that you should be doing your disclosures and you haven't. You have a certain amount of time to come into compliance. I saw it anywhere from 10 days. The state has 20 days for their compliance orders. The federal government has 60 days, a whole 2 months. So that was really kind of all over the board. But each time when I kept looking at these different ordinances, we saw these cure notices popping up because the idea is what we want is compliance above everything else. The second thing was ethics boards and commissions. Again, when we were looking at these different jurisdictions, we kept seeing these sort of independent ethics boards or commissions are the ones who are doing the investigation, having the hearings, and doing the recommended sanctions, something separate and apart from a traditional police investigation prosecution. We also saw that mayor and council staff is included in the definition. Currently, as I showed you in the previous slide, the definition of elected city official does not include council or mayor staff. And so a lobbyist could have contact with a staff member and that not be a violation instead of the direct council person. So again, that was incorporated in that definition, and we saw that time and time again when looking at lobbying ordinances. And then finally, electronic registration. Some of the jurisdictions we talked to, as soon as electronic registration came into play, all the cases went away because of ease of compliance. And that really goes up to that first point, is that by making it easy and something that everybody can do quite quickly, compliance really jumped up. So those were some of the best and common practices that we continually saw when we did our survey of the different jurisdictions. So with that, that brought us to 3 enforcement mechanisms we were bringing to the council today for action or direction as to what you would want to see in the amendment for the lobbying ordinance. So the first option is that of the Ethics Commission. As you know, you guys just passed an Ethics Commission as in February. And so this first option, what it would do is really piggyback that. We would use the Ethics Commission to do the investigation, to find the violation, make any kind of findings of fact, and then a recommended sanction. Obviously, violations through the Ethics Commission tend to be administrative and civil in nature, but that would comport with what we saw in some of the larger jurisdictions. The second option would be more of a hybrid. What we would do is we would use that Ethics Commission to take the violation, investigate, and then kind of make a probable cause finding. Do they believe a violation exists? And if they do, they would forward that to the prosecutor's office for prosecution. And then the third option would be a more traditional option, which is an investigation through the police department and prosecution through the city prosecutor's office. So what we would do in that instance is just put enforcement language on. If you violate registration or disclosure, it's a civil violation. If you violate registration or disclosure, it's a criminal violation, whatever the council decides, but that would be investigated through the police department and a standard prosecution through the prosecutor's office. So that's really today one of the first things that we're looking for direction on is out of those 3, what would you like to see in that amendment? The second item we're seeking direction on is sanction. So when considering how we're going to amend this particular ordinance, we can make it a civil violation. And to give you an example of what a civil violation could look like, the city of Chicago has it as a civil violation, and they have a $1,000 fine. Now, recently, they prosecuted or had a case involving an executive from Uber. And that executive had made contact with the mayor in regards to regulations. And what they did in that particular instance is every single day is a separate and distinct fine and violation. So it was 90 days that passed before that executive actually registered. So they ended up giving that Uber executive a $90,000 fine. It was a civil violation, and it was only $1,000, but over 90 days, it ended up being a $90,000 fine against that particular person. So that's one item or one way we could add a sanction onto it. A second is the standard criminal violation, and as you know, that comes with probation and jail terms. That's what we could do, and we could add some sort of criminal sanction to it. The second one that I kept seeing time and time again was a prohibition from lobbying. This would be essentially, we could do like a first violation. If a person is found responsible, they would be prohibited from registering for, say, 30 days, and they couldn't legally lobby in the city for that amount of time. A second violation, 60 days. A third violation, 90 days, whatever the council decides that they want to do. But we saw that in many of the ordinances as well. And then finally, a combination of progressive sanction. And what I mean by that is obviously we can combine a civil with a prohibition, a criminal with a prohibition, or have a progressive sanction. And I'm going to show you an example of that next. A progressive sanction would be, say, a first offense is a civil violation with a $500 fine per violation and that prohibition from lobbying for 30 days. A second offense within 84 months could still be a civil violation with a $1,000 fine per violation per day with the prohibition from lobbying. And then a third offense within 84 months, say, could be referred for criminal prosecution at that point if they've had a third violation in that amount. And we could still add on that prohibition from lobbying. But that's an example of what a progressive sanction could look like in regards to this ordinance. So we'll be asking for direction in regards to the enforcement mechanism and the sanction. But before we got there, I wanted to make sure you understood some of the things that we already have underway. And one of those things is the clerk's office has already started electronic registration, and that's targeted to be in effect for January 2018. And then also the 11th floor kiosk for registration, and that's really ready upon council direction. But those two things we already have underway in regards to lobbying. So our next steps, you give us direction as to what you want to see for the enforcement option and the sanction. We draft up that language, and then we bring it to full city council for approval. So with that, I am happy to take any questions.
All righty, any questions from my colleagues on giving directions or drafting language? Councilmember Gallegos?
Could you go back to the slide that showed the definition of official action?
Yes.
So you mentioned that official actions were taken by the city council. We also have some boards and commissions that take what I would consider to be decisive votes. So I'm thinking of the Board of Adjustment, so their actions are often final. Could one lobby the Board of Adjustment, or would that be?
The only way a person is under these definitions is if they are lobbying an elected city official, or if we add staff to the definition, or their staff. So if a person on the Board of that adjustments is not elected, then they wouldn't fall under that definition.
That's interesting, only because I know there are several commissions that make influential decisions and are lobbied. So how do we prevent that?
Well, you would have to change the definition as to what lobbying entails. So you would have to incorporate those boards. So in that definition, to communicate with any elected city official for the purposes of influencing a city action, you would have to change what you mean by elected a city official, or you would have to add, or boards and commissions, whatever it is, but you would have to add that to incorporate them into that.
I'd like you to bring us options where we might be able to.
So, Mr. Chairman, members of the subcommittee, we certainly could do that. We would change the definition of lobby, and we would change the definition of official action to include boards and commissions. That's not a difficult change to make if that was the direction.
I think particularly if they are the final decision maker, that seems, if they are an advisory board and commission, to me that.
So, again, Mr. Chairman, Councilwoman Gallego, what you're thinking is if board or commission essentially was not reviewed and its decision was effectively final, you would want that board or commission to be subject to the lobbying ordinance?
I haven't given this in-depth thought, but just as you read the definition of official action, it seemed to me it was more narrow than I
It
thought
is.
appropriate.
Okay. So you'd like us to come back with some other options?
And I confess
include
that this
board
was a
commission.
thought I first had 10 minutes ago, so would certainly welcome if you have,
So we'll flesh it out.
yes.
Perfect.
No,
Council, Vice Mayor?
I have a question. Lobby means communication with any elected city official for the purpose of influence official action. I have, I don't know if sitting in a grocery store line, happen to be standing next to somebody that in a neighborhood issue, we get to chatting. We talk about something that is happening within the neighborhood or that will affect a policy that would affect the neighborhoods. Would that be considered lobbying?
They're paid.
That's a great question, Chairman, Councilwoman, or Vice Mayor. The definition of a lobbyist is a person who is compensated to lobby. Now, people in the neighborhood who want to raise a neighborhood issue with you, whether in the grocery line or whether they come to your office, are generally speaking not considered lobbyists because they're not paid for that purpose to act on behalf of another.
But it's considered lobby by definition.
Not this definition, because this definition emphasizes compensation. So if they're not being compensated to lobby you, then they're not covered by the ordinance as currently written. We could, of course, make changes if you'd like.
I'm looking at bullet number 1. Communication with any elected city official for the purpose of influencing official action. So,
Mr. Chairman, Councilwoman Pastor, the two have to be read together.
okay, together, okay.
You're absolutely right.
my
That's a good
clarity.
point, but generally speaking, we would read them together, and so the lobbyist has to be compensated in order to be covered.
Okay, so I think we need to make that clear, that the two have to be together.
Okay.
Because I would say we are probably constantly being lobbied, using the term lobby, not lobbyist, but lobby, so.
We could actually change the lobbying definition to say means a communication by a lobbyist with an elected official, and then it would take that into account.
But
Thank
I'd
you.
like to have a list of all the boards and commissions that had the final say without going to the council. Because I think we have so many boards, commissions from villages that have to go to our planning, zoning, that if eventually we have the last say. So I'd like to figure out how many boards and commissions we actually have and which ones have the final say without coming to the council for final approval before even deciding to put some type of language in there about boards and commissions and all that. I think we need to do a little bit more homework on that.
Mr. Chairman, members of the subcommittee, we'll work with the staff and come up with a list of the boards and commissions that have final decision-making authority.
Councilmember Williams?
Thank you. I appreciate all the hard work that you've done on this. I know you've been working on this for quite a while. I have a couple questions. I happen, as you know, support that it goes to the Ethics Commission because this could influence any department in the city. They could be lobbying the police, for instance. Police shouldn't be investigating themselves.
Mm-hmm.
And the Ethics Commission is the least political of all. However, I guess my question is, when it comes to a criminal offense, if it's determined that's what's happened, would that automatically go to you for prosecution or the county attorney? I want to make sure that politics are eliminated along the line.
Mr. Chairman, Councilwoman Williams, generally speaking, we're writing on a clean slate here, so we can make some changes to accomplish the purposes that you direct us to do. Bottom line is, if you were to choose a criminal sanction, generally speaking, the procedure would be that if it went initially to the Ethics Commission for purposes of review and investigation, and they made essentially a probable cause determination or a determination that there was a reasonable basis to believe that the ordinance had been violated, then they could, if you so directed, refer it to the city prosecutor for prosecution, and it would go to the prosecutor.
Okay. I just want to be assured that, I mean, to me, it's two-pronged, that the criminal is much different than just the, I don't know how to explain it.
No,
The
Mr.
ethics violation, I mean, bad not failing to follow that is one thing. A criminal where you're actually
Prosecuted.
prosecuting or trying to bribe somebody or et cetera, that's totally different in my mind. And, you know, if that's the case, you know, they can go to the ultimate punishment. Failing to register, although serious, it isn't criminal in my mind.
Chairman,
And
no-
especially when we're making it easy, that you no longer have to file all the paperwork, you don't have to have everything notarized, and you can do it online, or we have a computer up on the 11th floor where if you didn't do it and you're new to it, you just go online right there and register. So there's no excuse. So I would think we would then say, you know, within 2 days, for instance, if they failed to see it in the lobby, we'll post it, I'm sure, so that they know that it's there, it's available. Then they're eligible to be sanctioned.
Chairman Nowakowski, Councilwoman Williams. Currently, the Ethics Commission ordinance indicates that that's one of the very first decisions that they decide is this something that we're considering, that we have jurisdiction over, or has another crime occurred? And if so, they immediately refer it for criminal prosecution. So if it's something like bribery, something that is separate from a registration and disclosure violation, then that immediately gets referred for prosecution. And that act, the act of the failure to register is stayed until the criminal act is prosecuted and dealt with.
Okay. That makes me more comfortable. I just want to make sure that all the bases are covered. I think what you're proposing is very workable. It should provide a penalty if people fail to register. And if they fail to register, shame on them, because you're making it very easy. There's not going to be any excuse for that failure. So I appreciate all you're doing and look forward to seeing this go forward.
Councilmember Gallegos?
We had yesterday at subcommittee had citizens who had 300 signatures to try to have a specific type of bicycle lane. And so that was very persuasive to me. I assumed they were doing it because they were motivated by safety in their community. If one of them worked for the company that made that type of technology to create the bicycle lane, that would have changed my decision. So could we, I mean, is there a way to incorporate that where there's that transparency if paid signature collection versus grassroots?
Mr. Chairman, Councilwoman Gallego, I believe that we could make some changes that would require further disclosures. The whole purpose of a lobbying ordinance, of course, is to further good government by transparency so that people understand who's effectively trying to influence the elected officials, or if we expand it to boards and commissions. And so if, as part of that, you want further transparency through disclosure, I don't think it's out of the realm of possibility that we could do some tinkering with this ordinance and come up with something like that. I understand that concern, that you thought it was all a grassroots movement. If there were a bunch of paid people in there, that might influence your decision a little differently. I understand that.
Because I do want to support citizens being more involved, and I would love to make it easier for citizens to be involved, but at the same time, I think it's important for us to understand if,
Somebody's paid.
right.
Or it could be a organic movement with a neighborhood leader, but the neighborhood leader is associated with a company that is going to benefit from that. So how do you, it's up to you guys, I guess, to figure that out on how we would nip that, or not nip it, but be transparent about it.
So, Mr. Chairman, Vice Mayor, long story short is that we came here today prepared to talk to you about lobbying. That what you're essentially asking us to do is to consider further disclosure requirements by people who are involved in some part of the decision-making process by city officials. We can do that. I don't think we're probably prepared today to tell you exactly the best way to do it, but if you direct us to go back and give some thought to that, we can do that.
Well, I look at it, I understand the whole lobbying piece, but see, lobbying happens at many different levels in this organization. Just does not happen with the elected official, and a lot of times it's not with elected officials, it's with people within the organization. And so I think this is a broader conversation. It may not be today's conversation, but it is a broader conversation because it happens. And how do we be transparent about it? The other piece is, what are the processes to then, I guess, register on this, or who comes in and visits with, I don't know, Alex in a department and registers there to say, I'm coming to visit Alex. I know it's broader, we're dealing with elected officials, but it is broader within our organization. And so I think that's something we can talk about further if we're really going to be transparent as an organization. So my question is, can you combine option 2 with possibly, if something is found, then there's language that then it would go to the police, or who does it go to? Or the prosecutor?
I'm sorry, can you ask that question again, Councilwoman?
I was
You
just
want
curious.
Option 2 and,
Between option 2 and option 3, an investigation through the police department. I don't necessarily mean there needs to be an investigation through the police department, that to be triggered right at the very beginning. But if there is something serious, what's the next step? Do they go to the police, or who do they go to?
Yeah.
If there's a civil or criminal.
Yeah, it depends on what you're talking about when you say something serious.
Well, if it's considered a civil or criminal complaint.
Right, that would be directed by the ordinance. So if you guys decide you want a violation of registration and disclosure documents to be a criminal violation, then that would go through the process of the police investigation and the prosecutor's office. If you want it to be a civil violation, then it can go through the Ethics Commission and then refer to the prosecutor's office for prosecution under the second option. So essentially what they would be doing is making that initial determination and investigation, making a quote-unquote probable cause finding that they believed a violation existed, and then it would be referred to us. If it's a criminal violation, then that would go through the police department. If it was a civil violation, then that would go through just straight to the prosecutor's office.
So it does cover, like 3 is kind of in 2. And,
2 is the hybrid of those two.
Of those 2.
Yes.
Got it. I just realized that. Thank you.
We regularly, as council members, visit businesses as part of our business retention strategy and ask them what we can do for them. They would not be required to register as lobbyists if they answer our question.
Chairman Nowakowski, Councilwoman Gallegos, no, because there's an exemption, and if you look in your CCR, those exemptions, if you're asking somebody just for information, to provide information, then that isn't lobbying. That's an exemption from registration.
Wonderful. And the same, we regularly hear from businesses or constituents. I say, what can we do better? They say, I have this business. If they say, please hire my t-shirt company to screen print your t-shirts, do they have to register as lobbyists?
Chairman Nowakowski, Councilwoman Gallego, that's a depends answer, because you are allowed to, this ordinance as drafted, and this was drafted in 1993, actually, in reaction to the scam scandal that occurred down at the Capitol. And so that's how long ago this was drafted. And when you read it and you look at the legislative history, it really looked as though it was drafted to capture paid lobbyists, people who are paid as lobbyists and to contact particular council persons to effect action. However, I think that there is a line if you are a CEO of a corporation, and this is covered in the lobbyist handbook as well, and a part of your job is to talk to council people in regards to, it may not be the main focus of your job, but you still, as part of your job, are required to talk to people, council individuals or mayors to influence action, then you should register. Because you are paid by that corporation to have this contact. So there are instances where it would fall, I believe, and there are instances where it wouldn't. It kind of depends on a specific factual situation.
but Mr. Chairman and Councilwoman Gallego, in that respect, remember that initially the purpose of the changes that we're recommending is not to impose sanctions, investigate and impose sanctions, is to encourage compliance. So we would first send out a cure notice in close cases. We would just simply say, hey, you engaged in an activity that appears to be lobbying, would you please register? And it'll be so easy, they can get online or come to the kiosk and register, and there's no fee to do it, and that it shouldn't be a problem in 99.99% of the cases.
And I think we might want to define compensation as well.
Okay. One of the things we considered is principal compensation. So if your principal compensation is to lobby, there are problems with definitions like that, but we'll take a look at it, see what we can do.
And I agree with Councilwoman Pastor that there are many people who make decisions at the city who are not elected officials. And if they are lobbied by people whose principal compensation is, then that's worth disclosing.
Vice Mayor?
I probably wouldn't consider it lobbying. But now that we're looking at it. My question is, so this is all, we're bringing now enforcement pieces to our ethics rule or our ethics ordinance policy. This is now bringing, I say meat because there's enforcement ability. Capability, not ability, capability.
Mr. Chairman, Vice Mayor, that's correct, that conceptually the way it would work, if you so directed us to go back and draft it this way, is that the meat of the investigation of a potential lobbyist violation could be sent to the Ethics Commission. That's one recommendation. The Ethics Commission then would conduct the investigation, similar to the ethics investigations you empowered them to conduct previously, and then they would make an initial determination of whether there was a violation or not for subsequent penalty, either through civil fine or by criminal enforcement, as the case may be.
Okay.
Councilmember Williams?
Thank you, Mr. Chair. Going to the sanctions, first, if I understand you, there would be the cure, is what you call it. You give them 5 days, and then the progressive could go in. Is that, am I following this correctly? Because I really kind of like what you've laid out here, but I think it's only fair you give them an option, especially as this is just instituted, that they know that they have to register and how easy it is to do. Once it's established, I'm probably not as forgiving, but up front I think it's important. But there are those who will try to avoid it. We all know, and there needs to be severe penalties, and I think what you've proposed is very good.
So Chairman Nowakowski, Councilwoman Williams, the way to look at that progressive sanctions slide is that, again, the cure notice comes first. So we give them a cure notice, as Jessica mentioned in her presentation. That could be anywhere from a short amount of time, like 1 business week, to as long as, for example, 60 days, the federal government does it. Again, the idea is you want to encourage compliance before you get to the level of talking about any kind of sanction, even if it were just a $500 penalty. So that would be our recommendation, because it's consistent with best practices that we saw when Jessica and the other lawyers in the prosecutor's office sort of surveyed the field out there.
Thank you.
Vice Mayor?
Can I ask the question that I have is, where did 84 months come from?
Chairman Nowakowski, Vice Mayor Pastor. It was just an example. We have an 84-month timeframe for DUIs, so priors with DUIs within 84 months. It was just an example to give you what one could look like. You could say in one's lifetime, you could say, I saw one ordinance that said within a year. So every year you start fresh. So it's really up to the council. Again, this was just an example to give you guys what it could look like. It's really up to you as to that time frame.
So if I made an offense, say, today, May. If I made an offense in May, and then a year from now, April, I make another offense. The second offense falls in with the 84 months, right?
Chairman Nowakowski, Vice Mayor Pastor, yes. So you would have essentially your time frame would be 5 years anything that you did in the last 5 years would count against you as to a first offense, second offense, or third offense.
So I think 84 months is 7 years.
Sorry, I apologize.
Yeah,
60 is
yeah.
5. I
Because I did the
apologize.
math. I did the
You
math.
are correct.
Okay. I think I would like to move the months to within 24 months.
So every 2 years they would start fresh?
Oh, no, 84 months is perfect.
Okay,
Okay. No, 84 months. Yeah. I was looking at it backwards.
okay.
That, yeah. Thank you for the clarity, though, because then I would have really let them off the hook.
And I apologize for my math.
Any other questions from my colleagues? So what we're hearing is that we really want it to be more transparent, that we want to make it easier for individuals, that if we can actually have some type of kiosk on the 11th floor where people can actually just sign in and register there on the spot, the compliance makes it, I mean, it goes up by about 80 or 90%, you were saying earlier. If not, a sign-in sheet or so at each council member's office, or online registration also, and looking at maybe an easier tab when you go onto phoenix.gov, that there's a tab there that lobbyists can actually just go directly to the registrations. Also, what I'm hearing is that boards and commissions, we got to really look at that and find out who has to decide the final decision that doesn't go to the council. Those individuals we really need to look at if we have to, if they have to comply or not. Other things that was brought up, especially from our vice mayor, and I was hearing from Councilmember Gallegos, was staff. We have some key staff that makes recommendations to the council and to the mayor, and those recommendations are positive or negative, and sometimes those are what we depend the basis of our votes on a lot of times. So those individuals also, is there some type of best practices out there in other cities throughout the country that keep those individuals that make those recommendations to, I guess, to council members, right? To pass policies and procedures and stuff, that how are they held accountable? So I think we have a lot of questions, but the other thing too is I think it's really important that we bring this to a policy, because I mean, there's 4 of us here and we're having all these questions thrown out. I know that those other colleagues, but you know, the mayor and my 4 other colleagues that aren't sitting on this subcommittee, they probably have some questions, and it's very educational. I mean, I agree with Councilmember Williams. This progressive way of doing it I like it. And I think that there might be some other comments from other council members that can add or to that. So I think I would like to really recommend this going to the next policy, and with the recommendations that you were hearing from here to put on there. And at policy, we can actually just continue this conversation with a larger group or work study or whatever you want to call it. So a study section where we can actually sit down and really work it out, because I think that's what's really important. The other thing too is that I believe that whatever we come out with is that we need to make sure that we implement it immediately and not wait until like next year, like we're doing with the Ethics Commission, right? We shouldn't wait until the Ethics Commission is formed next year to implement all this, that we should look at other means. If it's our city attorney, the prosecute office should take it, or I'm not sure, but we should figure out somebody meanwhile so we can actually implement this immediately. And also, I just really think that whole transparency and making it easy for people to register should be added on there. I'm not sure if there's anything else that we should add or something that I was missing. There's some definitions I know that some of my colleagues brought up that we need to define a little bit better. Anything else that I'm missing?
I think, Mr. Chair, I think we pretty much targeted what we're most interested in and send back for improvements in the language or expansion, et cetera. And I think as a temporary, you're on target, because the Ethics Commission won't be up and running, and I don't want to give somebody a year off. So I think a temporary solution would be very satisfactory.
Mr. Chairman.
I would just point out in the presentation, it indicated that the clerk's process won't be ready until January. So it's fine to start, but we're not fully able to make it as easy as it will be come January to register.
All right, we'll take all that into consideration also, yeah. But I think the sooner the better we start this conversation and we get this started and y'all working on it. So if we can work along with the mayor's office to put it on a work study or the next available meeting, that would be great. Any other questions?
I have one more, because I'm sitting here reading, dissecting language. 500 per violation? So how many violation could somebody possibly receive?
That Uber guy got.
Well, no, but I'm saying, it's saying 500 per violation, so.
Councilman Nowakowski, Vice Mayor Pastor, you could have lobbied more than one person
Okay.
and failed to register. You could have lobbied for a year and failed to file and be a registered lobbyist, but failed to file your quarterly reports as required by the ordinance. So there are different ways someone could have more than one violation. Additionally, the language that I mentioned in regards to Chicago, in addition to per violation, they made it per day. So each individual day was a new violation that could be subject to an additional fine. So as I indicated, the individual there didn't register for 90 days. So the Ethics Commission there decided that a $1,000 fine per day equaling $90,000 was an appropriate sanction in that particular case.
So do we have to put per day or?
Chairman,
I'm sorry, Chairman Nowakowski, Vice Mayor, we don't recommend a per day because, for example, in the Chicago case, he was being fined for Saturdays and Sundays. Saturday was at the park with his kids, Sunday was in church. Not sure that makes a whole lot of sense. It should be per violation, we believe. That would be our general recommendation. Of course, you could decide to do it per day, but we believe that would be very difficult to enforce, particularly since people aren't lobbying on Saturday and Sunday and legal holidays always. Now, sometimes they are, but not always.
Brad, I would rephrase that statement because somebody could call us on a Saturday morning
That's
and
true.
here I am on the phone. So I would rethink that a little bit because anything happens. I may be going to church with a member that lobbies for different companies and I'm in church and we're outside while our kids are playing and they're talking or getting something to drink. I think we have to relook at that.
Or dinner.
And certainly we
Yeah.
could, but in the hypothetical you just mentioned, if somebody lobbies you on Saturday, Sunday, that's a per violation. And that's easy to do. To charge them for a Saturday and Sunday that they didn't lobby you, that's the problem that I think Chicago's going to face trying to enforce that penalty.
But my question to you then is how would you know?
Because
Well,
either you report it,
at
or-
that moment, I'm at church praying, walking out, and somebody just happens to walk by me as our kids are together. I'm like, oh, yeah, I got that. Get in my car. Now I'm responsible for coming in and saying, oh my gosh, this happened on Sunday. What do I do?
Councilman, if I could, Councilman Nowakowski, Vice Mayor Pastor, that's why we're recommending the cure notice.
Okay.
Really, you would say, look, I was at church on Sunday and this happened, and I think this person is a paid lobbyist, and the city clerk's office would send out a letter, and that's one of the, and if they comply, that's the end of the story. If they don't, that's when the process starts.
Councilman or Chairman Nowakowski, Councilman Pastor, the only other thing that I would add as well is this wasn't supposed to be the language of the ordinance. This was just giving you an idea of what something could look like. We would adjust this in many different ways, but this wasn't presented to be the exact language in the ordinance. I was just trying to say this is what we could
Okay.
do, what it might look like. So I wouldn't take this word for word. It was really just to give you a general sense as to what a progressive sanction could look like.
Okay. And the only reason I'm asking these questions is because I'm thinking of scenarios in my head at this moment of, okay, now what does this mean to my life? And and to tell you, I have very good friends that our kids go to school with. So I'm now really going to have to be very cognizant of, okay, this is my kids' world, this is my political world. I mean, that's just kind of how our worlds blend together. And so it just becomes another challenge, I guess is what I'm saying. It's a good challenge, but it's just, we really have to be cognizant of what's happening.
Any other comments?
I just wanted to agree with Councilman Williams. In the long term, I think the Ethics Commission is the appropriate body to do the investigation as opposed to the police department.
So we'll ask the mayor to put on the next policy or work study that's available. And if you could maybe pass this PowerPoint presentation slides to our colleagues that weren't able to be here, and also to the mayor's office. And this way they can actually be updated by the time we get to that work session, right? Thank you. With that, we're on item number 9. Department budgets update. And we actually have a card on that. So I think before we have our staff come up here, go ahead and call Sean up to have comments. And then you actually have 1, 2, 3, 4 individuals that have given you their time. So you have up to about 8 minutes or so. So go.
All right. Well, good morning. My name is Shane Forbes, and I'm a resident of Northeast Phoenix. I, along with my friends, would like to provide you, this subcommittee, a little bit of information about the allocation of resources for public safety. I know that each of you are dedicated to making sure that the public safety is a high priority for the city of Phoenix. I also know that one of the primary concerns with public safety is, and always has been, how to use the financial resources available to provide the best and most efficient public safety services for citizens. I also know that the subcommittee is always looking for ways to enhance public safety, particularly when enhancements can occur without spending additional money beyond what is that in the budget. Because of this, and after learning about the concerns of this committee, we wanted to take some time to present an option that would enhance a core element of public safety, the booking process for misdemeanor offenses, and at the same time saving money which could then be redirected to the police department and enhance its operations. As you are aware, the Phoenix Police Department's central booking detail processed 29,000 prisoners in 2016. And after this processing, Phoenix paid more than $307 per prisoner to the Maricopa County Sheriff's Office as a booking fee. This initial booking fee equals over $8.9 million, and this figure does not include the prisoners that were taken directly to jail. There is a way within the current year budget to shift spending and to take advantage of current Phoenix facilities to eliminate more than half of this spending. By simply reallocating resources, more than $4.5 million could be redirected to police enforcement actions. The specific plan would be to renovate the current basement of city court to become the new central booking facility. Now, the court building is already designed to accommodate prisoner transport. It has a sally port, it has prisoner holding facilities already in place, and a space for personnel. What you might not know is that in the basement of the courthouse, there's also 2 large training rooms that are very rarely utilized, as well as an employee cafeteria that's not used at all except for holiday parties. By just renovating the 2 training rooms, the holding facility in the basement of the courthouse would be able to hold approximately 3 times the number of the prisoners that are currently processed through central booking. Because the basement is already set up to accept prisoners, the most costly requirements are in place, and that is the sally port and the secure elevator going upstairs. The cost of adding additional cells is little more than bringing in a contractor to create cells that are up to code by using cinder block walls. And the benefit of this plan would go far beyond a more efficient holding location. All right, if central booking is relocated to court, the prisoners would already be in the same building as the prosecutors, as the public defenders, and the judges. Initial appearances for nearly every prisoner who is who has been charged with misdemeanors, that would be able to be accomplished by simply bringing the prisoner up the elevator to see an on-call judge. we would be a lot closer to accomplishing a goal that Councilwoman Gallego has talked about for years, and that means that we would stop sending millions of Phoenix dollars to MCSO. This process is also more efficient. Instead of wasting time with the booking process of 4th Avenue Jail and seeing an initial appearance for the judge the next day, initial appearances would be accomplished immediately and in the same day. These efficiencies would also reduce the trips to MCSO's jail facility. It would allow our police department to reallocate detention officers to more important tasks that are currently underserved, including allowing these DOs to conduct wagon runs to the precincts. Right now, the majority of the arrests are resulting in officers needing to bring their prisoner to central booking themselves. But if this plan were to be implemented, patrol officers would complete their paperwork at the precincts and substations and rely on the wagons to transport prisoners to the court, allowing officers to be free to return to service instead of spending their time driving to central booking. This plan does not eliminate all misdemeanor transports by arresting officers. Combative prisoners would continue to be taken directly to jail, but by eliminating thousands of trips by patrol officers to central booking and by allowing for immediate initial appearances, tens of thousands of man-hours would be freed up and available to allow officers to focus on their core function in patrol. The savings could be redirected to allow detective details like FADE, like homicide, and the other specialty units to return to their appropriate staffing levels ahead of schedule. I know that everyone in this room agrees that the citizens are benefited most when they work together to bring creative solutions from idea to implementation. So moving central booking to court with minor renovations that could accomplish for far less than a single year's worth of savings is one of the rare win-win plans that benefits all of the stakeholders involved. Well, thank you for the opportunity to address the subcommittee, and I hope that we will be willing and able to work together in the future. If there are any questions, I have a little bit of information if anyone desires that. Thank you.
Thank you. Any questions or comments on that?
I guess I would love to get a reaction. I don't know if this is the appropriate time, but to the proposal.
You know, I think that because there's a lot of information and a lot of data that we need to gather. I mean, we were just talking right now, and I thought felonies, if you have a felony, do you have to be booked in the county jail or not? Could we handle that? I know that we've been talking in the past about video conferences with judges at our precinct jails and stuff like that. So I think we need to really have an update of all that, and also if we can look at central booking in general and have that as a future agenda item to look at if there is a way to save money and if there is a way to look at not booking so many individuals in the county jail and handling it at our court system that we have now. So I think that would be a future agenda item. I'm not sure about
I think that's a great suggestion. Thank you.
Right. Well, thank you for bringing that up. With that, we're on to our budget.
Good morning. Good morning, Mr. Chair and members of the subcommittee. I'm Jill Salai. I work for the police department, and I will give you an update of our budget through the end of March. And as of the end of March, our budget is $611 million. We spent $452 million, and we are right on budget right now. The month-to-month comparison, if you take a look at March compared this year to last year, there's really not much of a difference in the actuals that were spent. And then our top 10, most of them continue to be personal service type items. Our sworn career enhancement is less than what we had last year because of a lot of seasoned officers are either being promoted or retiring, so they're not receiving that enhanced pay. And then our equipment management charges are a little bit more than last year because of our aging fleet. And then finally, for our revenues collected, the biggest difference is for our grants, and a lot of that is because we're able to charge for the 2015 COPS hiring grant, so that has increased our revenues for those. And if you have any questions?
Any questions from my colleagues? Councilmember Williams?
Having the Final Four here, where does that fall in? I mean, you're right on target. You must have budgeted somewhere for the additional expense.
For the budget presentations, we do overall funding, it's all funds, and a lot of the Final Four hit the general fund, and we still haven't received all of those numbers yet of the actual overtime, so we're still gathering that information.
Okay, so we'll get that next month.
Yes.
Got it. Thank you.
Councilmember Gallego?
Could you talk about the change in court awards and what caused
The
this?
change in court awards is because we actually finished paying off the RMS contract for this year that we have been holding on to until we made sure we got what we needed for RMS. And then we actually had an additional fund balance, so we were able to program a little bit more. And so we used those funds for overtime for our Drug Enforcement Bureau for additional seizures, and also sometimes we use it for facility improvements.
Great, thank you.
Any other questions? Thank you.
Right, thank you.
Good morning, Chairman Nowakowski and members of the committee. I'm Ken Lake. I'll be presenting for the fire department's budget. And at this point in the year, at 75% of the year gone, we are at 72.4% spent. So we're just below our target right now, and I think we'll make it to the end on target. When comparing the variances between the months, there was nothing really that was outstanding. Again, we're on target. If you go all the way down to the bottom, you look at the last variance, we're right within where we expect it to be, with the budget for this year being 5% more than last year. And then much like the police department, our top 10 look very similar. The only thing of noteworthy is our constant staffing or constant manning fire is overtime that's used to staff our trucks. We're seeing a decrease there, which we believe has a direct correlation with hiring more firefighters. Outside of that, much like the police department, we're seeing a little bit of an uptick in the equipment management charges, which has to do with our overall fleet and the condition. And then as far as revenues, our ambulance transports were slightly down this year. When we did the analysis, trying to look into the reasons why, it really just points to we are transporting less people than we did last year. There's really no indicator that this is a trend or anything, but this is a cost recovery portion of what we do in the ambulance. And the same with dispatch fees and maintenance fees. We're right on target with that. That's a 100% cost recovery. And with that, be happy to take any questions.
Any questions from my colleagues? Thank you. Reports.
Good morning. I'm Will Gonzalez with the court. And as we get to our total budget, as you can see, we're 71.16%. We're a little under, but we're on target to finish out the year. And as you look at our monthly expenditures from last year compared to this year, we're at 2.46. So we are pretty much right there where we need to be on those monthly expenditures. As you look at our cumulative expenditures, the vast majority are just employee cost that we have, and that's consistent throughout the year. And as for revenues collected, you are looking at the current trend, and that is, filings are down, and so. But if you really look at this one, it's not as bad as it has been in the past. There seems to be a little creeping up on that, but that's where we're at currently on the revenues collected, and I can entertain any questions.
Any questions from my colleagues? I just really want to thank you all for being great stewards for keeping our budget and making sure that our tax dollars are spent wisely. And the reason that we have this is just to make sure that we keep you all in check, and also let the community know that you guys are working within your budget. So thank you. And it looks like by the end of the year, you'll be on target, or maybe even under budget. So that's great. Thank you.
Thank you.
So next is call to the public. Is there any other cards? Alrighty, then we have future agenda items. I think we had a couple already. Is anything else? I know one of the things that we've been talking about is that we need more police officers but at the same time, where the funding is gonna come. So if we can actually have maybe in the future, whatever time y'all need, to talk about if we did hire two per thousand or 2.5 per thousand, what programs would have to be cut to keep within our budget, zero budget, or what other means that are out there to raise the revenue to cover those expenses. Yeah. Anything else? Alrighty, thank you. Meeting's adjourned.